This project is supported by grant number 2019 YABXK001, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Department of Justice's Office of Justice Programs, which also includes the Bureau of Justice Statistics, the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, the Office for Victims of Crimes, and the SMART Office. Points of view or opinions in this program are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice.
In terms of format for today's program, we're going to begin with a presentation from Professor Brandon Garrett, and then it'll be followed by a Q&A session moderated by NACDL's President-elect, Andrew Burrell. So with that, despite the fact that he has a very long list of accomplishments on an amazingly wide array of subjects, Professor Garrett asked that I keep his introduction short, so I'm just going to say, Brandon Garrett is a professor at Duke Law, where he also serves as the director of the Wilson Center for Justice and Science. But I'm going to tell you, you should look him up and check out his work. It's really, truly spectacular. So with that, I'm going to turn things over to Brandon to get us started.
Great. Thank you so much, Bonnie. Thank you to the NACDL and to the funders and collaborators that make this whole series possible. Thank you all for spending your Friday afternoon with me. And I'm going to talk to you about some work that I've been doing over several years, including with some collaborators in computer science at Duke, where I teach at the law school. I also talk about this work in a new book that I've just written called Defending Due Process. So hopefully this can also help to frame some of the arguments that you can make when AI issues come up in criminal cases that you're working on. And Bonnie also mentioned that I founded a center at Duke called the Wilson Center for Science and Justice. We have an amicus lab and have been filing amicus briefs in general in cases where there are complicated, interesting scientific evidence issues. We are definitely people that should be on your short list of partners if there's a case raising appropriate issues in terms of a admissibility challenge to evidence that may have been affected by or generated by AI. So I'm going to talk about AI due process and scientific evidence today. I have some slides I'll share to help walk you through some of this. And please, yeah, as Bonnie said, post questions in the chat. I'll pause from time to time to take questions, and there'll be lots of time for questions at the end, I hope. So, okay, I'm sharing slides now. I'm kind of talking about two books today. I have a book that just came out this spring on the much more timely than I expected topic of procedural due process, something that my students don't often hear about procedural due process too much in law school. And as practicing lawyers, we often think of due process as very much in the background, since we have far more specific constitutional criminal procedure guarantees that, like the Sixth Amendment that this series is about, defending the Sixth. We have specific and more specifically applicable constitutional criminal procedure, and we have specific case law that digests and provides often more particularized standards for any given setting in a criminal case. But I think actually some of the issues that many types of AI systems raise, well, they do implicate particular confrontation rights, particular rules of evidence, but they also implicate kind of procedural due process writ broadly. Like, can you have notice and an opportunity to be heard, just basic procedural due process, if you don't know what an AI system is or how it works? Some of this does relate to my last book, which is about forensic evidence. And how do we think about the reliability of forensic evidence? How can we safeguard the reliability of forensic evidence? And if it's not of appropriate reliability, or if it's of unknown reliability, what tools do we have to challenge basic types of forensic evidence that have been introduced for decades? But many of these disciplines have come under real scrutiny due to more recent scientific research. that was that was the last book. The current book is about due process, and I'm going to talk about the chapter on AI and some of the underlying work. I'm going to focus on the underlying work in my talk today. Uh, so, just as a procedural due process 101, although again, we're often more focused on specific guarantees, fundamental due process means that we have notice and an opportunity to be heard before the government is trying to take our life, liberty, or property. Now, we tend not to have to think about that much in criminal cases. Like, of course, if someone is arrested and charged with a crime, there's notice in the form of an indictment or an information. Like, we should know what the charges are. We know what this criminal case is about, and that the probable cause was found. There was some initial presentation of a factual basis. Then ultimately, if the case moves towards trial, the government has to do a lot more to meet its due process burden and to satisfy the beyond a reasonable doubt standard. Uh, but pressing questions are raised if the government is trying to say, well, there's probable cause, or yeah, there's evidence that supports a conviction in this case based on something that we can't give you notice of, and therefore, how do you respond to it? And that is a problem that some AI systems pose for us. If they really are inscrutable, if we don't know how they work, then what is the basis for probable cause if it was a hit or a thumbs up from an AI system? And can you actually exercise your confrontation rights, or can the government fairly rely on evidence that is based on a system where they can't say how it works because the AI system was designed in that way? I think that actually raises, in addition to, again, specific criminal procedure guarantees, this larger due process question. Do you have fair notice if what the government is relying on is a black box? Uh, these issues are starting to come up in criminal cases in a variety of different settings. Um, One setting has been DNA probabilistic genotyping software. There's been litigation over that for several years now. There's been litigation concerning risk assessments, which we can talk about a little bit here and there, which are typically not generated through machine learning or AI, but they're developed by researchers and they're quantitative. But increasingly, we are seeing challenges where it is an artificial intelligence system that may have or did generate evidence. So we'll talk more about whether it matters how you define AI. We'll table that for a second, just to highlight how these things are starting to come into court. This excerpt is from a case just a little over a year ago in Seattle, where a shooting took place, and like can increasingly happen these days, someone had a smartphone and took a video of what happened. But it was a nighttime event. The video was kind of dark and grainy, and the defense wanted the jury to really see what happened on that video that the witness took, because it was, depending on where people were standing, there was the defense wanted to use that video to support their argument that it was self-defense. And so they wanted to enhance the video to give the jury a better look of the scene. And the prosecution objected to this enhancement and said, well, wait a minute, what did your expert do? Washington is a Frye state, not a Daubert state. But like in many Frye states, the inquiry was very Daubert-esque, and the judge is asking, well, how reliable is your expert? What did your expert do to enhance the video? How do I know that the video wasn't altered in a way that could be misleading to the jury? And the judge questioned the expert, asking the expert, well, okay, well, how did you enhance the video? And the expert says, well, I use software. And the judge says, well, is the software, I've heard of generative AI. That's a thing these days where AI actually creates new information. My understanding is like the video, once you enhanced it, has a lot more pixels than it had before. Were those pixels created through generative AI? The expert says, I don't know. And the judge says, well, how does this system work? Is it AI? The expert says, well, it's the software we use. Like it's software that we often use to enhance videos. But I can't tell you, like I'm not the developer. And so the judge ultimately concludes that, well, if we don't know whether it's generative, whether new information was created, and if new information was created, how reliable was it? How has this software been validated? How does it work? To use a tool like that of unknown reliability raises real questions. And we don't want to be misleading the fact finder. And so, if this wasn't peer reviewed, if we don't have assurances that this software was reliable, then we shouldn't be relying on it. So the judge said that this expert would be excluded. I mean, I think there's a separate interesting question. Is this person even an expert? if they can't say how the software works, if they don't know what the tool is. Now, experts do rely on tools. They're not always just reaching their own judgments without relying on technology or software. And maybe we feel comfortable with that if they can explain why the technology or software has been vetted adequately. Um, Now, one wonders, was the judge extra skeptical here because it was a defense expert, and the judge is less accustomed to seeing the defense having an expert? The judge, in fact, even noted that, well, the prosecution said the standard software that they use to enhance videos is a different system, implying maybe that the prosecution experts, they probably know what the right software is. I don't trust this defense expert. No matter whether it's a prosecution or a defense expert, we should have some assurance that the software being used, if it's being used to enhance or alter evidence that the jury is going to see, we need to know whether it's reliable or not. And so, although this wasn't a defense-friendly ruling, this is something that any lawyer should be able to use, and that these questions should be asked in any jurisdiction about whether AI was used by an expert. And of course, the problem with an AI system like this is that it doesn't explain how it works. This expert had no idea how it works. The expert just kind of ran the software, just like if we, touch up a photo on a smartphone. We don't know how it works. All we know is that the photo looks touched up. And maybe we like how it looks. The stakes are very low if it's just we want to make the image lighter to share with our friends. But if we're trying to introduce evidence in a case, that really shouldn't be appropriate. So I want to now talk about some terminology, and hopefully this is helpful. There's a pretty short 5 or 6 page article that walks through these definitions and walks through our basic approach that I co-authored with Cynthia Rudin, who's a colleague in the computer science department in the engineering school at Duke. And by the way, I'm fortunate that Cynthia runs the world's leading laboratory that does interpretable machine learning. And so I've really benefited from her and also her graduate students and students' work. And we've collaborated on a number of different projects, some of which I'll talk about today. But it's just been a wonderful thing about being at Duke that I've gotten to know the Cynthia and colleagues who are the leaders in doing interpretable AI. And what is that? Well, first, I don't think it's very interesting or important for our purposes as lawyers to talk about what does it mean for intelligence to be artificial, and is it really intelligence? Can machines really think like people? Like that's a fascinating topic for philosophers to talk about, but we are more practically minded. I think a working definition which suits any of our purposes perfectly well, that we can call it AI if it's a machine that's performing a task that typically humans would do. And so not all AI necessarily has to be fancy. We typically think of something as involving AI when it's not just an algorithm that we could have designed and usually do design in advance ourselves without the help of a machine. So if it's just an algorithm for converting miles to kilometers or Fahrenheit to Celsius, okay, that's a really simple algorithm. People designed those things. If it's a more complicated algorithm or code where we actually like a computer actually came up with it. We asked it to come up with like what's a good way of associating, not Fahrenheit to Celsius and back, but temperatures, you know, across all of the states during the month of April. And we have some sense which states might be warmer than others during those months, but we actually fed in the data and asked it to come up with a good mapping of that. Well, then maybe we figure that's the kind of task which a human could have done, but to look through that quantity of data and find those associations certainly saved a lot of time to ask the machine to make those associations itself. So I don't know that it's important for the purposes that we care about in the legal system to have like a precise definition of artificial intelligence. And in fact, the federal government definitions have typically been somewhat broad like this, just using machines to perform tasks that normally require intelligence. That works fine. Which again means like AI can be a label that we add to things that some of which are really complicated, some of which are fairly simple. So the term transparency in AI can, in general, like explainability, interpretable, open AI, transparent AI, a lot of these terms get used interchangeably in ways that are really confusing and unclear. sometimes intentionally so, sometimes because computer scientists aren't lawyers. We tend to focus on being more careful about definitions than people in other professions. That's why we can be so annoying to our friends and family. Uh, Cynthia and I'm fortunate to work with a computer scientist who does like to think like a lawyer and be precise about definitions, think that it really is important to get these terms straight. Because often we hear that some AI system, well, it's open or it's transparent, or it's interpretable, and it actually isn't in key ways that matters. So in some ways, like if people would prefer to use the word explainable to refer to one thing versus another, that's fine, but you can't let the definitions slide into each other. So first on um, transparency, starting at the bottom, uh, we use that term to refer to actually providing training data and code to permit testing. Like, can you actually test this AI system to find out how good it is? And you may be able to accomplish that to test the system and assess its reliability um, just by having access to the model. You may not need to have the code printed out. If you just run it on different data, you may be able to see how it performs when you run it on different data. So, you may just need access to the model and not the actual code. Printing out the code may not be very helpful. There have been some courts that say, "Oh, defense, you're interested in the code. You want to know how this AI works? We'll order the government to make it available to you, printed on pieces of paper." And that's useless. You can't run something printed on pieces of paper. It would take an enormous amount of work to enter that code and to create software around it and actually test it. So you may just need access to the model. You may need the training data to find out how it was developed. But then again, testing it on new data may be good enough to find out how it performs under realistic conditions. Uh, so by transparency, we just mean what access do you need to test the reliability, test the performance of this system. Um, by openness, OpenAI tends to involve actually disclosing the model, the code, making the model available like open source. We talk about open data too, where you share the data itself that you developed it on. And there can be concerns, like if it's an AI system that has, um, there would be national security concerns with other governments using that model. Um, maybe it's not such a good thing for this to be shared open with the world so that anyone can use it. Um, and importantly, like you may not need to share the model with everyone in the world in order to test it and find out how good it is. Um, Sometimes there may be real public value in everyone having access to the model so they can do things with it and build on it. But there can be trade-offs. The two terms that we think are particularly important to think about, especially in the context of rights and rules of evidence, is the difference between interpretability and explainability. Some AI systems describe themselves as interpretable or explainable. They use either word, but really they are only providing an explanation. They are explainable in that they say something about what they did, but they aren't telling you what they actually did. So the system may say, in general, what we do when we provide a facial recognition hit is we measure distances between particular features on the face. And faces with the closestly aligned distances, those are the ones that we rank the highest. Uh, or in general, when we provide pretrial risk scores, we're focusing on the person's age and the number of priors, and we give the most weight to that in general. Well, they're not telling you what weight they gave or what features or data they relied on in this particular case to make a recommendation in this particular case. That's what we call interpretability, where they actually tells you what it calculated to make the prediction, like what the model did, not in general, but in this particular instance. What did it rely on to conclude that this person poses a risk of reoffense pretrial? That this particular person poses a risk of reoffending on probation, or that this particular face is one that's closely associated with the image from the crime scene. That's interpretability, where it actually tells you what factors it did rely on. Now, um, many of the AI, if not most or almost all of the AI systems being marketed, aren't designed to be interpretable. They let the machine do its thing. The machine does, whatever, using whatever analysis it does. It forms connections based on the data that it is fed, looking for the outcomes it's instructed to look for. It may develop its own code, and it may absolutely find patterns that an individual person or a whole team of people never could have found on their own. Um, and then once the designer concludes that, yeah, it's found patterns and the predictions it's making seem really good. They meet our threshold for how reliable we'd want them to be. So it's a black box, but it's a black box that seems to be performing really well. And we've tested it on some different data sets. It's good. We're happy with the black box. That's typically how these things are designed, and it's a lot easier to do that. We don't have to know how it works. If it just seems to be working well on the data we fed to it, then we're good with it. Now we sell it. Now we use it. Uh, it does take a decision in advance to say, no, 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 we're going to design this in advance to, yes, we're going to take full advantage of the machine and learning and whatever neural networks or whatever it's using. But we're instructing in advance to keep account of whatever associations it's making in the data and give those association weights and disclose those so that when it does any given analysis, it tells us what weights it relied on and in what way. So the model is actually set out in general and when it's applied in a particular, based on a particular request. Now, one of the big goals of Cynthia Rudin's work and some of our writing together, and we have a law review article in the Cornell Law Review. This is the short free version here on PNAS. That's like 6 pages long. That's open access. The Cornell Law Review article is also open to the public. It's much longer. One of the arguments that is often made by developers, and many judges have heeded this and said, oh, well, you know what? We wouldn't want to disclose to the defense how this AI system works. They may say that it's a due process issue, that they deserve notice, that they need to be able to contest the evidence. But if we ask them to do that, and we're not even sure it can be done, then there wouldn't be incentive to take advantage of this incredible technology. And, artificial intelligence, it's changing our lives, it's reshaping the world. It's doing all kinds of things that we never would have thought computers could do. It can detect patterns that we never would have seen. It can beat people at the hardest games on earth, like Go, chess, whatever. All those advantages of AI, they would be ruined if you forced AI to reduce itself to some little checklist or algorithm that people could understand. If you said you have to boil it all down to a couple of factors and weights, like those are the kind of algorithms that we used to have, like checklists or the kinds of things that pretrial services people would fill out when they fill out like a simple risk assessment, like the public safety instrument, the PSA that is used in a lot of places around the country. That thing is easy. That's like a simple algorithm or the product of a simple regression. That's not what we're doing now with artificial intelligence. So we would be, we want to incentivize developers to use these amazing tools to do these amazing things because they perform so well and they have advantages for society. So we don't want to disclose this stuff because we want to incentivize the creation of these amazing tools. And we've seen judges say that when they explain why they deny defense requests to get more discovery about whatever it is, facial recognition. This has come up a lot in the probabilistic genotyping context. Developers of that software, they're doing great things. We want to incentivize a market to do that great stuff, and they shouldn't have to disclose how it works. Well, Cynthia Rudin has asked over the years, okay, if that's right, that black box AI performs so much better, well, then surely they should be willing to enter into a little competition. Like, let's see if it actually performs better. You say interpretable models are so simple, they're so Mickey Mouse, they're elementary, they don't have the full advantages of AI. We're using the full advantages of AI in our lab. We just ask it in advance. Once it finds all the associations, maybe hidden ones that people never would have noticed, it has to then boil it back down to something that actually explains what it actually does. And we're scientists. You can't just claim that your system performs better. You have to show us that it performs better. And so they've done that. So here's an example of a very, very simple interpretable model. And they developed it using data on how the COMPASS risk assessment instrument had been used in Broward County, Florida, where people were able to get, through FOIAs and journalists wrote about this, how this risk assessment was being used in that county, and you had people's scores and data going back years about people's offending and reoffending rates. And so Compass has 137 outputs. We don't know whether it counts as the kind of AI where machine learning was used to develop the model. It may have been a human developed model, and people picked those 137 inputs and said these are really predictive. And so it may just be a really complicated algorithm, or maybe it was developed using machine learning, which is more like what we think of as AI today. Whatever it is, it's a complicated model, and it's black box. Maybe not by design, but by choice. The company has refused to share how its model works or what weight those 137 inputs have. In fact, researchers trying to reverse engineer it think that it may only be that like two of those inputs really matter, the person's age and maybe not even their priors, maybe just their sex. Maybe being male and being of low age is mostly what the system is relying on. In which case, why do you have to fill in information on those other 135 things? It's a lot of work. Anyway, Cynthia Rudin and colleagues found that in terms of performance, that this very simple model performed as well or better. And this model, I mean, it's not written out super well here, and they weren't trying to create a better risk assessment instrument. They weren't trying to suggest that this is fairer or that it would be good for justice for this to be used, but they showed that this performs better. If the person has, more than 3 priors and is 18 to 20, or is a little bit older and has 2 or 3 priors, then they have a greater risk of being rearrested. That's it. So it's relying on 2 age bands and numbers of priors. It's very simple, and they can set it out with weights and how much greater that prediction is. It's extremely simple. You can put it on a note card. And so the question is, well, why use something black box and proprietary if it could actually be very simple and understandable and could be set out on a piece of paper? And a bail magistrate can look at that and know what they're actually relying on when they're making a decision that, oh, wait a minute, actually, this person actually does seem high risk versus not. Whereas if it's a black box and all you have thumbs up, high risk, do you really know what you were doing? Is that actually due process? How does a person fairly challenge a determination by a magistrate? If the magistrate says, oh yeah, Compass told me, thumbs up, you're going to jail. How do you contest that? How can you say, well, no, I think your thumb should be down. Like I'm a first-time offender. I'm employed. I have close ties to the community. Like, what can I tell you? What can I tell you that would change your mind? The magistrate would have to, if they were being honest, they would say, well, actually, nothing you can tell me can change my mind because it's not my mind. I have no idea how this thing works. It just said thumbs up. And so I'm supposed to keep my thumb up. If the model is set out like this, then there's a lot more that someone can say. They actually have notice. They actually have due process. They can say, your administrative data is wrong. It says I'm thumbs up because I have more than 3 prior crimes. Actually, 2 of the 3, there were 3, but the 2 of them have been expunged, or the charges were dismissed. Or I am no longer 20 years old. You clearly have my age wrong. They enter it a different way, all the time. The sheriff's staff isn't always accurate. But in fact, I'm 22 years old now. I'm not in that category. And so you might think that category is high risk, but that's not me. There are all sorts of arguments one can make. Or, yes, I had 3 priors. You might think I was high risk based on those. But that was during a time when I was homeless, and each of those priors was for trespass. And I wasn't able to legally live anywhere without trespassing. But now I'm housed. There's no chance I'm going to be trespassing anymore because I have my own home, and I'm very happy to be there. All sorts of arguments you can make to situate the data that a system is relying on if you know what it's relying on. But if it's a black box, there's no fair way that you can make any arguments, and there's no fair way that a magistrate can justify their decision. The judge doesn't know what they are doing. They're no better than the defense expert in Seattle who says, I don't know, I just pressed the button. It enhances the video. I don't know how. I don't know how well. Just looks better to me. So as we all know now, AI systems can also make wild errors. And if they are a black box, then we don't know why. So this is a fun example that my colleague Cynthia likes, where an AI system concluded that this cute husky dog was a flute. We have no idea why it concluded the husky was a flute. Was it that its paw seemed like it was flute shaped, or its long nose, or like what was the thing? Like there's this heat map that's on it. What does that heat map mean? We have no idea. Like, how does that tell us that it somehow overlaid a heat map on the image and says, that's how I made my decision? That tells us nothing about how it can make such an egregious mistake. So we can't understand mistakes. We certainly can't correct them. And so we really don't know what we're relying on. We don't know what we're relying on if it's right. We also don't know what we're relying on if it's making a serious mistake. And we don't know how to prevent those mistakes from occurring. We all know too from experience, and I do a lot of work with different administrative data sets at the Wilson Center, that errors in criminal justice data are frequent. I mean, it makes work really challenging and time consuming sometimes when you're trying to see, uh, you know, how many priors does this person have, or how often do people reoffend in misdemeanor cases when their name is spelled three different ways each time, or five different ways, or their gender, their race, their age, all entered different ways. Often the data entry person is someone booking them at the jail, and if they can copy something off of ID, then maybe that will be consistent and it'll reflect their driver's license. There still might be typos though. But what if every other time the person doesn't have ID and the person is not answering questions because they're experiencing behavioral health crisis or because they're angry to be there? Or for whatever reason. Sometimes then the staffer and sheriff staffer may just be guessing or copying over what was last in the system or whatever. Like their job isn't to be doing perfect data entry. And so there are all kinds of errors, which means that if there is historical data that a risk assessment is relying on in a particular person's case to say this person is high risk, there could be errors in that data. And in fact, when Cynthia and her colleagues were looking at the Compass scores in Florida, in that county, Broward, they found that it wasn't just that their interpretable system, which like no one should pay for, it's simple, it's free, you could write it down on a piece of paper. It wasn't just that, but they suggested that it looked like there were a ton of errors in the Compass scoring of people. And since it was a black box, no one could catch them because you didn't know what it was relying on. But it looked like all kinds of people who were extremely high risk were in fact being released, and people who are low risk were not. It was making errors in both directions. And so, these kinds of black box systems, it's not just like a defense-friendly argument. It is a real concern for public safety if you're relying on something where it's not just that you don't know how good it is in general, but you don't know how good its prediction is in a given case because of the case-specific data that it's relying on. And you can't correct those errors or even identify them if it's a black box and you don't know, like you would if it was interpretable, what factors is it actually relying on with what weights? What are the most important factors it's relying on in this person's case? And if you know that, then everyone can agree, oh yes, this person has several priors. That's what the system cares about. That's why it's predictive. We feel good about relying on that in this case versus not. We don't feel good about relying on it at all because those priors aren't accurately entered. They've been expunged. This person has aged out of that category. They're of a very different kind, all sorts of different things. So these tools can be very useful, and so I'm not trying to suggest that we shouldn't rely on artificial intelligence. I think interpretable AI is of great use in the criminal system. This is if you're interested, it's a computer science paper where we used an interpretable model that Cynthia and her colleagues developed, colleagues both in the statistics department and the computer science department, to look at outcomes among the people who receive pretrial services in Durham, North Carolina, where I live, where I work at Duke. These are people who are risk scored as low risk and were referred to the pretrial services agency for pretrial supervision. And those people were eligible for diversion from the jail. We compared them to people who did not get into the pretrial supervision program, many of whom also didn't end up in the jail because these were misdemeanor cases typically. And people either didn't, there was no real bail or they made it or charges got dismissed. And what we found actually is that we could use an interpretable AI software program to compare the people who got the treatment, the pretrial services versus not, across all sorts of different characteristics. And we found that none of those characteristics were predictive of like extra success with the pretrial supervision. That basically we could convincingly show using this software that all these people were low risk. None of them needed to benefit from this pretrial supervision program. They should all be released to the community. Now, that doesn't mean that judges read the study and decide, oh, good, now we can release everyone. As far as I know, that hasn't happened. But that was the lesson that we learned from this very sophisticated comparison of all the people who both did and didn't benefit from this pretrial supervision. And without doing like a real-time experiment, we were able to use AI to compare these people in every possible characteristic. The machine can run, hundreds of thousands of different possible comparison groups. And so it was like a computer-done experiment, which was really interesting. Um, and we wish it, had a bigger impact on local policymakers to be able to show that that you don't need any particular degree of supervision of people who are charged with low-level offenses and who are really low risk. There's a separate question, especially if it's not interpretable AI, but actually even if it is, do judges or other criminal justice decision makers understand what they're relying on, and are they relying on it in fair and unbiased or sensible ways? And so there are a lot of things that the state of Virginia did right when it rolled out a risk assessment designed to divert people convicted of certain felonies from prison. And the idea was just because you're convicted of a felon doesn't mean you need to be in a state prison. And we don't want our prisons to be overcrowded. And so people who are identified as lower risk, like we should divert them to the community, to jails, or ideally just to community supervision. And they actually incorporated that approach into their sentencing guidelines. It was in advisory guidelines. And they had researchers look at repeat offending data and identify categories of people who had felony convictions who were very unlikely to repeat offend. And they actually did something, they set out something that was quite interpretable. It's a simple worksheet which says, you get 6 points for having prior felonies. You get certain numbers of points for age. And so it's a simple worksheet that can be filled out easily by a court clerk. And you can see what weight each sort of factor has. And so, or you could correct errors if something was filled out wrong. But unfortunately, what we found is that far less than half of the people eligible for release were getting it, that many judges were ignoring the calculations, sometimes releasing actually the high-risk people, often not releasing the low-risk people who are eligible. But we found when we surveyed judges that many of them had only limited awareness of this risk assessment. They didn't understand how it worked. They asked, like, has this thing even been validated? When in fact, the Sentencing Commission had hired researchers to develop it. The research was public. They repeatedly redid the research to check on it and revalidate it. Like, they did a pretty responsible job of trying to develop something that was reliable. But none of that information about why judges should trust it had been shared with them. So they had no idea. And understandably, many of them didn't trust it. We asked the Sentencing Commission, well, what kind of training do they get on this? Because if there's this quantitative tool, it's not really AI. It's a simple regression set out in a nice interpretable checklist, nothing fancy. But judges need to be trained on it if we want them to be relying on it consistently. And there were real disparities in how they relied on it. It tended to be in rural jurisdictions, judges trusted it even less and rarely used it. In larger jurisdictions, judges tended to use it more. And the Sentencing Commission sort of at the time said, oh, no, don't worry. Like, judges are absolutely trained on this. And we're like, oh, we'd love to, what kind of training materials are there? And they showed us a slide that the judges get in their onboarding. And so like a slide, like that's definitely not enough to promote careful use of some kind of a quantitative tool. So there's definitely a concern with the human element. How do people use these tools? And what do we know about how they're using them in practice? That's something that we studied in Durham, North Carolina, and we've just started working on a study in Fayetteville, where one understandable reaction to these complicated tools, which may be AI, maybe not, but they're black box, is like, well, how realistically do we study these things? How do we know how they're affecting law enforcement, prosecutors, judges? Well, one way we can study is just to see what happens when they implement these tools and compare before or after, or compare places where they're using it versus places where they're not. And so we don't need to have access to the model. We don't need to know how the black box works. We can just assess, well, what does it do to the performance of the people that are using it? And that's what we did in Durham, where the city council wanted to know, is ShotSpotter, which has these, they put up these sensors around town to pick up noises and identify gunshots. And the claim is that it'll help police get to the scene faster and ideally solve more shootings, maybe even prevent shootings, because people will know that they'll get caught so much more readily if they discharge a firearm in the zone. at least outside, not inside. It doesn't work for indoor locations. Anyway, we did a 12-month study with the help of a wonderful recent PhD graduate, Adam Solomon, and the hardest working professor emeritus at Duke, Phil Cook. And the results suggested that, we don't know how ShotSpotter works. We have some limited information from the company, but there's a zone where they implemented it. And in that zone, while the response time did go down to incidents, vast numbers of those notifications were shown to not be verified as involving shots. That, more than half were not confirmed gunshots. And there were no arrests made that resulted from having this system. And so, the city council ultimately concluded that while improving response times is not a bad thing, that we would want more measurable benefits from using this system. We don't know how it works. It's a black box. We know some things about, okay, it involves sensors and picking up sounds and triangulating. But treating it as a black box, we can still ask whether using it was effective or not. And without more evidence of effectiveness, we don't want to spend a huge amount of money on it. And I thought that was the right thing to do, that the government should be piloting and evaluating these tools before committing to spending a lot of taxpayer money on it, especially if it could affect the work of law enforcement and affect people's rights. There's a real concern that, and this is, as far as I know, come up at least once or twice with ShotSpotter as well, that if it's a black box system and they can't tell you how it works, what happens if something is contested in court in a criminal case? And should the government really be using a system where a vendor is saying, oh, well, we can't disclose? Because in a criminal case, you have to disclose if someone is going to have due process. There are two cases where this has come up for facial recognition technology, where, these systems in general, make associations between different features on faces and map those and compare them across large databases of faces. But there's a big National Academy of Sciences report that came out last year evaluating facial recognition technology. Cynthia Rudin, the computer scientist who I collaborate with, served on that committee. And the report identified lots of concerns with how reliable these systems are, particularly with grainier images and images of black men, like Mr. Arteaga here. These systems seem to have been better normed on white faces and male faces. And there's very little testing of these systems. There's a voluntary testing program that the federal NIST agency has had, but for any given police agency, like, are they using software that has been submitted to NIST for voluntary testing? And only recently have they done testing where it's more realistic images that are not like perfect mugshot type images, where we know that these systems perform much better if it's a great face forward, high quality image. But if it's a grainier image, where the face isn't facing perfectly straight, then it's a little similar to the issues like with firearms and fingerprint pattern evidence, where if you had a temp print card from someone where someone was required to leave very good prints for employment purposes or whatever, there's a lot of information there. But if it's a partial smudged print, then we really worry about accuracy far more. Same thing with faces. And in two different cases, the defense has litigated, well, we want access to more information about how this facial recognition software works. What's in the black box? Not only that, but what did it actually spit out in this case? It may not be interpretable, may not tell us what factors it relies on or with what weights, but it did give a whole series of hits. If it's instructed to give the top 25 matches, it'll give the top 25 matches. If you tell it to return 50, then it'll return 50. So we want to know what other photos it returns. Those could be alternative suspects. And those could be people that we would want to investigate. We should have Brady versus Maryland access to that. It could be exculpatory. We don't know. In this Florida case, the trial judge and the appeals court affirmed, said you don't get discovery on that. Since we don't know whether it was exculpatory or not, and it's quite circular in Catch-22. Like, you don't get it because we don't know if it's exculpatory. And the defense says, well, we would know if it was exculpatory if we could look at it. The New Jersey court in the Arteaga case rejected that kind of circular argument and said, yeah, the defense it may be quite powerfully exculpatory. We need to know how this picture was selected to show to the witness in this case. We absolutely understand that there are due process protections around the reliability of eyewitness identifications. So how was this lineup came out of, it originated from a facial recognition search. So we need to know how the software works. How reliable was it? Was it tested? And what other candidate photos did it select? Um, Mr. Arteaga's face? Was it the third face, the 10th face? There's also a strong human element, and the Arteaga court really emphasized that, which is important. We need to know how well validated the system is. These systems are not designed to be interpretable. I think they should be. They should be telling you what in a face that they are relying on in general, but also for a specific face. Um, but there's also the human element where there's a human analyst, a facial recognition analyst who is looking at whatever it is that if they instruct it to return the top 25 faces that it thinks have the most similarity to the face in that image. Um, well, the human examiner is going through those 25 and ultimately picking one to potentially put in a photo array to show to the eyewitness. And how does that person do that? Well, that person can turn over any of those photos and look at the person's criminal history. They get all kinds of biasing information, and they're exercising their own judgment, which is not based on AI or anything like that. They may be biased, though, by how high up someone's picture was in the list, or the background in that picture, or other things. They also may be biased by the person's address, their criminal record. They can see that stuff. If they're doing a facial recognition search in a robbery case and they see someone has 2 prior robberies and lives in town, they may be much more inclined to pick that photo, and that's the person whose photo then ends up in the lineup. And so the Arteaga court really spoke to how there's concerns about the reliability of the technology, but also how it is used by the human users, and that these are all things that affect the reliability of the central evidence in a case. And the eyewitness is going to be a powerful witness at trial. We need to know how the eyewitness came to make this identification, so we need a full hearing on this. I do think that there is more support behind these due process arguments around the use of black box AI now that Rule 702 has been amended. It's been over a year now. And the two changes to Rule 702 highlight that it is the burden on the party proffering an expert to show that their expert meets all the Rule 702 criteria, whether it's the more Daubert-oriented criteria regarding the reliability of the method, or the separate emphasis in Rule 702 that we need to care about the reliability of how the method was applied in this case, and also the reliability of the opinions and conclusions that an expert reached. And so whether it's a defense expert, like in the Seattle case, or a prosecution expert, if the expert basically says, I ran AI and it says there's a hit, this rule change should add greater weight to the defense argument that, wait a minute, it's the burden on the party trying to introduce this expert to show that what the expert did is reliable. And if the expert can't explain what this AI is, if it's a black box to them, that's not enough. Some courts have even said, well, but this isn't just any expert, it's the developer. And the developer says it's good, and they've tested it, and like works, the developer says it works 99% of the time. That's not independent evaluation. That's not peer review. That's the developer say so. If the burden is on the party trying to introduce the expert to show that this is more than likely than not reliable evidence, that this is true scientific evidence, the developer say so should be neither here nor there. I do think that these amendments are valuable, and the advisory committee notes really emphasize how one of the impetus for making these amendments was the concern in criminal cases with forensic expert testimony that all too often these experts don't disclose and can't say anything about known or potential error rates. If their method is a black box, either because of the human black box, the person says, I look at fingerprints for a living and I find the matches and I just do it based on my training, based on my experience, based on my judgment. Well, then they are a black box. They're just making calls. And ipse dixit of an expert is not enough. They can't just say, I'm the expert because that's what I do. Well, similarly, if it's software, the software is the expert because that's what it does. That same exact concern. The Rule 702 amendment is really helpful in that regard. It's also helpful and really should apply in the same way to states that haven't yet adopted the most recent version of Rule 702. Because the advisory committee notes also emphasize that while these are substantive changes, these were designed to highlight things that should have always been obvious to all judges. We shouldn't have needed to make these amendments. And that's why judges shouldn't have to wait till the language is changed in their jurisdiction, because they highlight that it was always true that for any rule of evidence, the proponent needs to show that any applicable rules of evidence are satisfied. The burden is always on the proponent. We shouldn't have had to amend the rule to highlight that. And it should have always have been obvious that the ultimate conclusions an expert reaches has to flow from their methods. They can't just use some methods and then reach conclusions that have nothing to do with those methods. That should have always have been obvious. We're adding this language to emphasize it because some judges have gotten it wrong, have sort of presumed that experts are admissible, and have presumed that whatever they say on the stand, that's fine. As long as their method is good, whatever they say is fine. The advisory committee notes really emphasize that no, that was always clearly wrong. We shouldn't have had to amend this rule, except that judges had misunderstood Rule 702 so badly. A couple of other things I wanted to highlight and then stop and take questions. It can be a whole other side of my research has been looking at mock jurors and how they evaluate forensic evidence. And we found it really valuable for the defense to have its own expert to highlight the lack of reliability or the lack of research on the reliability of prosecution methods. And that could be valuable for traditional forensics. This is a study that we did looking at fingerprint evidence. I think equally valuable for AI, for an expert to say, like, they can't tell you how reliable that facial recognition system is. There are concerns with the reliability of such systems. I don't know how reliable their system is. Neither do they. It's a black box. Some software developer made it. They're not disclosing anything about how it works. And that raises great concern. And, it could be a statistician saying, I don't do facial recognition for a living, but I know that to know how reliable something is, you need to know some things about base rates and what are the false positives, what are the false negatives when you do performance assessments of it. If that doesn't exist, if that kind of testing doesn't exist, then we don't know how reliable any of its conclusions are. We don't know what the level of statistical uncertainty is. We just can't say. Sort of statistics 101, that you have to have statistics, and we don't have that for this kind of software. So I'm not a software developer, I'm a statistician. But you can't say probabilistic things about something where you don't have a statistical basis for saying anything at all. Statistics have done that in cases involving traditional forensics, like hair comparisons and the like. Same principle applies if it's AI. And they say, just like a hair comparison expert is a black box, I just look at hairs and I reach a conclusion, I make a call. If it's an AI system that reaches a conclusion and makes a call, and we don't know how validated it is, we don't know how often it gets it right, how often it gets it wrong, same concern. But we found it really very valuable to have that methods-only expert, a defense expert that didn't also look at the fingerprints in this study, but is just speaking to the underlying limitations of the methods. We found that really affected mock jurors. I have links to lots of these different mock jury studies if you're interested in reading more about these studies. One common theme is that jurors are very receptive to information about error rates, the proficiency of an expert. They want to know how good an expert is, how good a method is. We don't have a problem of people uncritically accepting science in this country. That said, people do assume that whatever it is, a firearms examiner, fingerprint examiner, if they say they can make a match, people figure, oh, I guess they can. But they really are receptive to information about reliability because they don't just trust experts. They would like to know how good this person really is. On confrontation rights, I mentioned this briefly before, and I want to wind down and take questions. We talk about this in detail in our Cornell Law Review article piece, but you can't meaningfully confront someone who can't answer questions about their methods because they don't know what they are. And if someone is using a black box AI, then you can't confront them. You can't confront that. And courts are going to have to grapple with this, and they should. There's a separate concern that AI may stay out of court when it's used in ways that implicate people's due process rights. Mr. Arteaga in New Jersey ultimately pleaded. He'd been held pretrial for 2 years, and while he got a very good decision at trial and on appeal in his case, saying that they should have access to the facial recognition technology. Is he going to litigate this to trial? It may take more years. Does he want to take that risk? He ultimately concluded that making more good law was not worth it to his family. And that is a real concern if these black box AI systems aren't challenged because they're just used in support of probable cause, or they're not actually introduced in evidence, but they lead to people being detained. They lead to people pleading and sacrificing their rights because they don't want to take the risk of challenging the evidence at trial. And so it's it's a real concern. What are the ways that we can raise challenges to this type of evidence, or think about legislative solutions if it's affecting cases early in the pipeline at the probable cause stages where you're not applying Daubert, where you don't have a chance to fully challenge the evidence or get discovery on it. So I want to stop there for now and take questions, but I can talk more about anything that we've discussed. Interpretability, AI, how do people use it in practice? I see there are a few questions in the Q&A, so I could start with those. Oh, so I see first question here is about reliability and repeatability. And actually, Cynthia and I have just finished another article highlighting how, and this is something that she thought, like, we shouldn't write an article on this. It's just sort of basic science that, of course, you test an AI system and you know how reliable it is. And on repeatability, you know that it's reliable not just on the data that you fed to it, but on other data. Like that's what you do to validate any scientific tool. What I'm interested in is it interpretable? Can people understand what it actually did? And I was kind of like, oh, no, 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 Cynthia, you have no idea. There are these tools that are being rolled out, including in criminal settings, where we don't know that they have actually been carefully tested, where we don't know that there is repeatability. It's been tested on other data to see how good it is, or whether there's replicability, whether other independent researchers have had a chance to test it and confirm that, yeah, it actually works the way the developers say it did. She's like, really? But that's just basic science. If you're going to say that something works, if you're that, experimental results stand up or whatever it is, you have to let other people test it. And, you have to share it, not just to peer reviewers, but other researchers. It's just sort of basic science. And I was like, yeah, basic science is not happening in many of these fields. It's not like people have access to facial recognition systems so they can run it themselves and see how reliable it is. I mean, the best we have is this NIST, voluntary testing program. And so we describe how important it is and how judges need to understand that just because the developer says super accurate, works 100% of the time, um, that's not testing. That's not replicability. That's not repeatability. We need to know if it was tested on other data, if it's independently tested by someone who doesn't have a profit motive. Well, how good is the system then? Does it hold up? And so it's incredibly important that judges be educated on these concepts because sometimes judges have often said, developer says it's good, must be good. Or there's like a publication out there. That seems like science and peer review. Well, if was the publication authored by the developer and two of the developer's staff, that's kind of often what happens. So there's a real need to push judges on assuring that these systems have actually been independently and robustly tested. It's often not the case. There are also no rules requiring that be the case. The Biden administration issued this AI Bill of Rights, and they said, federal agencies, like you need to think about this, and the Office of Management and Budget, OMB, they issued procurement guidelines last March saying, okay, if we're procuring AI systems around the federal government anywhere, we need to be assured that it has been adequately tested, especially in areas that impact people's rights, like, say, criminal law uses of AI. We need to know that it's been rigorously tested on realistic data, not just like in-house data. We need to see that data. We need to independently assure ourselves that this is good if we're going to be using it. Well, the AI Bill of Rights got struck, this past January, so it's no longer in place. But that was the kind of thing that you would want government to have. Like we shouldn't be paying for this and using it unless we are sure it works as intended, and validating that ourselves, not just accepting the developers say so. I mean, it's totally fine if we're not sure how reliable something is, if it's just making movie recommendations to us. We can see for ourselves that, like, okay, I don't like any of these movies it's recommending. I'm not using it. If it's being used in a criminal case where rights are at stake, we need to know a lot more. And unfortunately, there are very few guardrails.
I can see there are a ton of questions already piling up, and there's
Yeah.
some more that have been showing up in the chat. I want to bring Andy in and take a moment to just introduce folks to Andy Burrell. So Andy, as I mentioned, is not only NACDL's president-elect, Andy chairs NACDL's AI task force. He's in private practice in Minnesota, where he handles both state and federal cases, does both trial and appellate work. And I think he has a couple of questions for you, and we're going to go ahead and work our way through those.
One of the questions is, what steps can be taken to avoid the risk of AI perpetuating biases?
Yeah, and that's a great question, and thanks to our viewer for asking it. So one danger is that if AI, if what a predictive AI system is doing is it's making predictions based on stuff that happened in the past. The data that it may be trained on may be biased data, right? It may predict that a person in a given neighborhood is a lot more likely to be rearrested for driving while intoxicated, but it may be that that's the only place that police are setting up breathalyzers and doing checkpoints because it's an over-policed neighborhood. There's a concern that there'll be a garbage data in, garbage data out um, problem with uses of AI. And that's why people do need to know what data was it tested on, and is it actually accurate and reliable if you give it different data, if you give it data from a different neighborhood or a different city. We need to know a lot more than just, oh yeah, it predicts. Um, it's a concern with the facial recognition. If it's just trained on white male faces like mine, uh, does it do poorly on faces of other ages, genders, races? And there's evidence that it does. Or if it's just trained on really good mug shots where you're just, squarely in the image, may work fine when you're walking through the airport and you look at the camera because you're okay with that and just want to get to your gate. But you're looking straight at the camera. How well does it do on more realistic video footage where people aren't looking straight at the camera and trying to put their face right in the center like instructed? Um, so the, the, these are all the kind of questions that we need to know before the government is using it in criminal cases. And these are all the kind of questions that we want to be putting to experts if they're going to try to testify about evidence generated by or informed by these types of systems. I saw there's a question from Lisa about the report on facial recognition. So it was the National Academy of Sciences report from last year, which talked about the reliability of facial recognition evidence. And a big emphasis there was the need for adequate testing and how it does seem to perform really differently depending on the data that it was trained on. And so they called for a lot more research on that.
Clay asks whether there are currently any high-level court cases or rulings challenging the use of AI.
Yeah, there are some tort cases that I don't know that any have reached judgment yet, um, but a number of people have uh, been concededly, like law enforcement has conceded, they falsely arrested them based on an erroneous facial recognition hit. There's some real outrageous cases of people who, were clearly not the person depicted. There were also some cases where there were even deeper pockets worth a tort suit to a civil lawyer looking for, a deeper pocket than local law enforcement. There were a couple cases coming out of shopping malls I think it was like the extended Houston area in Harris County, where shopping malls had contracted with a facial recognition vendor, and they had reported people, "Oh, this is the one who mugged our sunglass hut," and there was a man who didn't even live in Texas, lived in California, who was arrested and assaulted brutally in jail based on this facial recognition system that this vendor had been using in a shopping mall. Um, and so I know there are several different civil suits that have been filed around the country. And, we hope that civil suits create incentives for companies and law enforcement to be more careful and to respect people's rights. And hopefully over time, um, that helps to temper their enthusiasm for technology that isn't as reliable as it should be. But of course, that takes time, and those cases can take time to proceed to a settlement or a verdict. The damages that are paid may be covered by insurance. It's those certainly the stories of miscarriages of justice have started to impact the conversation around some of the uses of this technology, and some of those anecdotes, even though we want systematic testing, we don't want to just be relying on anecdotes. But if we don't have systematic testing, we do at least, we are starting to accumulate some powerful anecdotes of people who have been who've had terrible loss of rights and terrible harm to them based on errors in these technologies. And those can be fodder for cross-examination and for briefing in court as well.
So these are both tort cases and 1983 cases? Is
I
that?
think there's some of both. I think there's some tort cases where there was people who were sort of the police got a case referred to them based on a private company, the whatever it was, the parent company of the sunglass hut, whereas some other cases where people were arrested by police based on their own use of facial recognition.
What do you see as the implications of generative AI for criminal justice?
Yeah, so this is another kind of thing where my computer scientist friend who I was writing with, Cynthia, was kind of like, we don't even need to address generative AI because you would never use that in criminal justice. Generative AI, that you're making up data. Why would you ever? No one would make up data for court in criminal cases. We should be mostly focused on predictive models because, of course, based on good data, you can sometimes make informative predictions, or at least you know how good they are, and sometimes that could be useful in criminal cases. But we don't even need to address the topic of generative AI in our writing together because that's just ridiculous. Well, it's no longer ridiculous. Just to give one example, last summer, Axon, which is the leading provider of body cam systems around the country, rolled out a product, and we're all seeing AI-enabled things pop up on devices and software without us even asking for it. Well, law enforcement were told, well, there's this free add-on called Draft One, which is can now turn body cam footage into a police report. And there's not much more fundamental to the initiation of a criminal case than a police report. That's a really important document. And the idea that something the equivalent of ChatGPT could be composing that police report raised lots of alarm bells. Um, it hasn't been adequately validated. Axon says, oh no, we have a validation study. We gave a whole bunch of these draft one generated reports to human reviewers and also some police reports that police officers wrote. And the human reviewers found actually, they didn't know which was which, but they found the ones that were generated by draft one to be way more readable and clear than the ones that police officers wrote. That may be true, but the real question is like, are they accurate? Do they have hallucinations like we've seen ChatGPT use? Any of us who've played with it can easily get it to say all kinds of ridiculous things if we use the right prompts. And I guess to their credit, they said, well, this performs best if it's a very simple, like sort of a one-on-one encounter. We don't know how well it does if the body cam is capturing multiple people discussing things. And by the way, it's not just like purely generating a police report. The officer has to check off on it after having certified that they've read it. And that's really their police report. It's just a drafting assistant. It's just like a lawyer using ChatGPT to draft a cover letter. But of course, you have to edit it yourself and make sure any cites are correct. And that's what the police officer will do if they use this. And they'll be certifying that. Uh, Now, I guess one difference between that use of generative text and maybe some others, um, maybe kind of more like that Washington case. Like to the extent that you're worried that a video enhancement software may have done something misleading, well, you can look at the original video and compare. Um, and maybe it wasn't so unfair what the defense expert was doing there after all. If you look at it and say, well, I don't know, it's lighter, we can see what's going on, but they didn't add anything, they didn't change the way the gun was pointed, it's fine. Well, similarly, to the extent that draft one creates a police report that's full of problems, if the defense has the body cam video itself, they can check. And if the officer actually signed off on a report that has clear errors and you can see where those errors are by watching the video, that might be wonderful fodder for the defense, actually. And so I've heard some defense lawyers say, like, sure, go with it. If they want to risk making serious errors by relying on some software to generate police reports, they're signing off on it. If they're swearing that this is true, and we can easily catch errors or catch them using words that really aren't their own even, or that are misleading. Let them do it because police officers write inaccurate and biased things all the time. But this is an example of something where we can actually cross-check. But there may be other settings where these technologies are used where it's not so easy to cross-check and where we'd have even deeper concerns. Well, like something like Compass, where a risk prediction is made and we have no idea how it makes it. So, but I think we will increasingly see these tools, and there's a much bigger concern if it's generative, where it is making up information, it's making up data. That is not something we should lightly tolerate in a criminal case.
What about state and local regulations?
Yeah, so there are some now. There are some jurisdictions that have said some things about facial recognition. They haven't been very effective to date, and we definitely need another generation of regulation in this country. Some jurisdictions have said, you can't exclusively rely on a facial recognition search as the basis for probable cause. There needs to be something else because we don't know how good this AI is and how reliable these hits are. Um, But in practice, what often happens is, oh yes, we have independent corroborative evidence. We have the facial recognition analyst who says, yeah, I think it's the guy too. But that's not exactly independent corroboration. But in many cases, that's what agencies are relying on in addition to the facial recognition hit. It's like, I looked at the hit and it's good. That's the corroboration. And so that has been a thin. What we don't have is states saying we need to know what independent testing was done, how reliable it is, under what circumstances. All that has to be disclosed publicly. We need judges, we need defense lawyers, we need prosecutors to know what the police officers to know what are the strengths and limitations of these systems. We need to know how often they produce false positives, false negatives in different circumstances. Like we actually need to know how good this is when we're using it in cases, and all that needs to be disclosed. No jurisdiction does that. No one is requiring rigorous testing. We often don't know, and I think there's some really important FOIA work to be done. Like, the local law enforcement agencies near you, what facial recognition systems are they using? Are they using other types of AI-enabled tools? Just like with other types of policing technology, license plate readers and the like, they often don't have to disclose what tools they're using. They could be using something off the shelf. They could be using the FBI system. They could be using multiple things. It could be an individual officer likes to run facial recognition searches on his smartphone, and the agency doesn't even approve it. So we really need to be regulating the uses of these technologies, and instead it has often been a free-for-all.
So there's a really interesting question here from an anonymous attendee. I'm going to just read it. We challenged FRT having been used to include my client in a photo array, after which the eyewitness identified him. The judge denied, saying that the witness's ID from the photo array not only cured any problems from the AI FRT, but proved that it was accurate. Do you know of any studies that show an increase in misidentification when FRT is used to populate a photo array?
So that is a concern that the National Academy of Sciences flagged itself, including because there's one question is like, how do we do that study exactly? Like, what do we know about how agencies show photos that resulted from a facial recognition search to an eyewitness? Is the eyewitness told, guess what? We did a facial recognition search and this amazing AI software. Pick this guy's image. Does it look good to you? Like that would be a really suggestive show up. Or they provided a proper photo array and they're not told anything about the use of AI. It's just we may or may not have identified a suspect. Don't assume that just because we're showing you these photos that we have a suspect. You don't need to make an identification. The investigation will continue. But here are the 6 photos. Take your time, look at them, let us know what you think. Whatever it is, the standard instructions. There's nothing AI specific. It is not a show up. Like maybe then the lineup is more independent of the technology. It's just a regular lineup. Even then, there are questions about how was that picture chosen? Did the human analyst pick the one that they liked the most? Did they pick the person who had prior arrests in the area? Was the eyewitness told, by the way, you made the right choice, and this is someone who's, we picked this person because they've been involved in 6 different robberies right in that neighborhood. There are all kinds of questions about whether the person could be biased by the way the analyst ran the facial recognition search, looked at the candidates. There's definitely protocols that could be put into place to minimize that kind of bias and spillover. But the concern is that when the facial recognition is used, a lot of things may be done that we would normally not tolerate because we understand that it would be highly suggestive in the context of an eyewitness and a regular photo array. Are those regular rules about photo arrays being followed when facial recognition is being used? Most agencies don't have policies on that. They have lineup policies, photo array policies, often going back 10, 20 years. Many agencies in many states have updated those policies because there's a lot of research on eyewitness misidentifications. And law enforcement has really taken on a lot of that research, which has been an important thing. But a lot of agencies do not have ground rules for using facial recognition to pick photos. And so there's a concern that all of that work to try to to make lineups objective and to try not to suggest things to eyewitnesses. And we know how malleable the memory of eyewitnesses are and how bad people are with faces. We want to preserve their memory and not contaminate it. Concern is all that will go out the window if no policy is followed when lineups are informed by facial recognition. So it's a big problem. The National Academy of Sciences report flags all these concerns, but we don't have good research on how bad the problem is. I'd like to do some at the Wilson Center. We're going to do a little bit this summer. It's not a good time to be getting research grants to do this kind of research. We wish there was more federal support for this kind of research. It takes that kind of sustained support to do this kind of work, but there's a real need for it, and it's a great question.
What you talked a little bit about this before, but what are the ways to challenge AI as presented by experts at trial?
I mean, one question is like, is this person really an expert if they can't explain what the tool is? It's fine if an expert relies on a tool which is standard in the field and they can say things about how well it works and how it's calibrated. And yes, like I didn't invent, our modern understanding of DNA, and we have tools that we use to replicate DNA from a sample and to amplify it. And I can tell you general things about how it works, but I can point to all the studies that have been done that validate it. It's standard to use this equipment in the field. And no, I'm not an expert on every step of the process. That's fine. But if the expert is largely relying on this tool, and they can't tell you that it's been validated or how it works, that's a big problem. That should fundamentally raise questions about whether this person is really an expert, whether they could possibly satisfy Daubert, and whether you can confront them. Because if they can't answer any questions about what they did, then you really need to be able to confront the person who actually knows the tool that's being used. And so who is that person? Who can tell you what the tool is and how it works? If no one can do that, then it shouldn't be in evidence.
Here's a good question. Are the algorithms upon which AI programs are used peer reviewed?
Many of these tools, we have no idea whether they are, and they may not be. It's definitely common in computer science to not share code, to not peer review these tools. A lot of what computer scientists do is to develop tools that are never intended for use in the legal system or in criminal cases. They just don't have that in mind. They don't have due process in mind. They aren't trying to show that this is like fundamental science. They're just developing interesting computer science tools. And so there's definitely a different research culture than in other sciences, like in medicine, or where peer review is important because they understand that to convince regulators that this drug can be safely used, we need to have all the proper peer reviews, and we need to have controlled trials, and we need to be able to assure that it performs as we hope it does, in order to convince the regulators to allow this to be used in the medical profession. That there isn't the research support for that kind of peer review and independent scientific testing in forensic disciplines. There actually was a big federally funded Center for Statistics and Applications in Forensic Evidence called CSAFE. Its funding actually ended about a year ago. But there have been some congressional efforts to try to create more research support for forensics so that there is that kind of independent testing. But in general, for forensics, there has been hundreds of millions of dollars for building forensic data banks, for equipment for crime laboratories and the like, but kind of like way less than pennies on the dollar in terms of actually funding the research we need to know whether these forensics are good or not. We've been lucky in the DNA area where that wasn't developed just for criminal cases. It wasn't developed mostly for criminal cases. Forensics was like a lucky side benefit we got, but DNA was, technology came out of multi-billion-dollar investments because everyone understood that DNA research was going to fundamentally transform whole fields of medicine, health. And so, the biosciences, biostatisticians, all sorts of leading scientists were, engaged in an arms race to decode the genome. They were investing billions of dollars in our understanding of DNA. And there just happen to be very powerful side benefits for some types of criminal cases where that testing can tell us something about identity of a culprit. But but most of these other disciplines were never researched or developed in the sciences based on any thinking that there would be applications in science or in other fields.
So a person asks, and I guess this seems like a good question to perhaps end on. It says, based on what you're saying, then we should really file really specific discovery requests along with retaining our own expert witnesses to determine subjective bias along with reliability, ?
I think so. I think, I mean, there's such a world of difference in civil cases where both sides often have experts and there's a battle of the experts in terms of judges being educated that, wait a minute, this isn't just unquestionably expert evidence. This isn't just, this isn't undisputed science. When you have two experts, then all of a sudden a judge can see that, well, wait a minute, there may be different ways of approaching this, or there's actual disagreement about whether this is a valid method, or whether there's any valid method here. And it's very hard for any of us who are not scientists or have any quantitative background. I never took statistics. Like, how are we supposed to do that on our own without an expert? Obviously, it can be a challenge to find such experts, to get such experts funded, but certainly in our mock jury studies, we found it's really, really powerful, even just to have a methods expert to say, like, I don't know what they're using. It seems to be a black box, but let me tell you about the kind of validations you need to be assured that something is reliable and we could trust it for high stakes decisions like you would be needing to make in a criminal case. Having an expert like that can really matter. Obviously, it's great if this is someone who says, I've myself performed testing on facial recognition systems. I can tell you why they fail. I have concerns about this one. That would be even better if you had someone who had actually dug into this kind of system. It would be even better still if it's an expert who has dug into the specific system. But even a general expert, a general methods expert can really help to educate the jury, because often the expert may not know how the system works, or they may sort of work for the developer and they say, this is great software, it's the best. That's why this county uses it. All I can tell you is that we've tested it, works perfectly. The jury will have nothing else to go on if that's all they hear. And so they need to hear another perspective. And cross-examination isn't going to be able to effectively break that out if no matter what question you ask that person, they say, I'm using the ultimate software. It's just so good. All I can tell you is it's great.
Works every time. Yeah.
Works every time. And we had that problem with traditional experts too, obviously. I'm a fingerprint expert. They used to say, I can exclude this person. No other prints in the world could have made these prints. No other fingers in the world could have made these prints. I've never made a mistake. I'm in fact infallible. It's based on my training, experience, and judgment. I've never made a mistake. And in fact, I've done work in hundreds of thousands of cases. That person is a human black box, and they say, like, I'm infallible. I'm superhuman. Trust me. Like, how do you cross-examine that person? I mean, it's on its face ridiculous, but jurors, uncritically accepted that testimony. The scientific community weighed in, and the field has backed off of those kinds of claims in fingerprinting, at least to some extent. They say much more modest things than they did 20 years ago. Hopefully that will happen, but only with vigorous challenges, because we sort of are seeing the same thing repeat itself, where it's not the fingerprint expert, it's an AI system saying, like, it found a match to the face. This is the best match, perfect match. And you know how good computers are compared to human eyewitnesses. This is amazing. All the faces, there are billions of faces in this database, and this is the one it picked. Now, we're not seeing that yet at trial. It's being used in support of probable cause largely. Instead, that image is being shown to the eyewitness. But the concern is that the AI may be contaminating the evidence at trial, may be contaminating the eyewitness. And so, we're seeing obviously more and more fruit for challenges. At the Wilson Center, we are very enthusiastic about joining efforts to write amicus briefs and to add a scientific perspective to challenges to this evidence. We're Center for Science and Justice. We care about statistics. We care about using research. We like using technology. We think that analyzing data is important. We're not, Luddites, but we think that it needs to be used with the appropriate research so that we know it's actually good for what it's being used for.
I wanted to personally thank you, Professor Garrett, on behalf of NACDL and all the attendees today for the important work you're doing and for taking the time to explain what you're thinking in this area and to answer some of these questions. It's really appreciated, and thank you so much.
It was such a treat to join you all.